Is it absolutely necessary to get a contract even if you're working with family or friends?
It's always necessary, especially with family and friends. The reason is that you don't know what's going to happen as the business starts to grow. Situations change, people's perceptions change. And if anything, you want to protect the friendship or the familiar relationship. Having a contract does that. It removes any uncertainty, removes any problems, because since you agreed to this very early on, it'll protect all parties involved.
Is it absolutely necessary to sign a prenuptial agreement?
Well, I wouldn't say absolutely, but it's highly recommended. In the case that divorce takes place, you want to make sure that all assets have already been distributed and you've determined what's going to happen with assets upon the dissolution of a marriage. So having a properly drafted prenuptial agreement will ensure that. It will protect all parties and make sure that if there is a divorce, everything will be okay.
Why should we have an attorney at a closing?
Well, an attorney acts as an insurance policy. What they'll do is they'll ensure that everything is written appropriately so that there's no problems, such as the address or the legal description that you're about to sign onto with the contract price are exactly the way they should be. And that any specific terms, such as dealing with associations or any type of issues with title, have been already resolved. An attorney is knowledgeable in these areas and they'll ensure that your rights are protected with the last few documents before you take over the property.
Is every detail at a closing that essential?
Oh yes, they can be very essential, especially when you're talking about the legal description of the property address. Case in point, you could have a situation where the property next to you is vacant lot, yours is the property you want, and this by switching one number, now you're saying you're buying a property that's vacant. Now in certain situations you say, well, the individual owner doesn't own that property, but if it happens to be a developer, they own both. Now you could end up owning a vacant lot without a home on it.
Does a contract always have to be in writing?
Absolutely not. You can have what are known as oral contracts. And oral contracts have just as much validity as a written contract. Now there are certain exceptions, such as a contract for real estate does require a writing, and a contract for goods greater than $500 usually requires a writing as well. But generally speaking, an oral contract is as enforceable as a written one.
How do you enforce an oral contract?
Well, an oral contract can be enforced just like a written one. You simply go to the other individual and enforce the terms that they had agreed to. Now if they choose not to agree to them, then at that point you may want to hire a licensed attorney like those at our firm who can help you in enforcing your rights with respect to the contract. Witnesses aren't necessarily essential, however, they do ensure that your rights are protected. Since it's an oral contract, it's very difficult to prove one's terms when there's only two individuals. So having witnesses does allow the ability to defend your position with respect to what was agreed to.
So what exactly does SG Law Group specialize in?
Well, we specialize in 4 areas: corporate services, real estate, estate planning, and property insurance matters.
What kind of corporate services exactly?
Well, we offer things such as incorporations, contract review, contract negotiation, dissolutions, mergers, and even commercial litigation.